Unconstitutional Acts. The court follows the decision of the highest court in the state in construing the Constitution and the laws of the state, unless they conflict with or impair the efficacy of some principle of the Constitution or of the federal statutes, a rule of the commercial or general law. The decision of the state courts and questions relating to the existence of its subordinate tribunals and the eligibility of election or appointment of their officers and the passage of its laws are conclusive upon federal courts. Now, the most important thing is, while acts of de facto incumbent of an office lawfully created by law and existing are often held to be binding from reasons of public policy. That's a very important point. Public policy. You want to watch out for the term public policy. It is often confused with the state's right of eminent domain of police powers. Police powers and public policy are almost the same thing, except that one is done without law because they want to, and the other is done because they reclaiming a police authority to do so. When they talking about public policy, the acts of the person assuming to fill and perform the duties of an office which does not exist can have no validity whatever in law. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protections. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Now, if you take these basic cases that we have gone over so far, you will have gone a long way in getting your constitutional rights back. This book, Citizen's Handbook, it includes the Constitution, jury instructions, arguments, and a lot more. Some of the important arguments in it go along with what I've been talking about. All laws which are repugnant to the Constitution are null and void. Marbury v. Madison, 5 U.S. 137. Where rights secured by the Constitution are involved, there can be no rule or law-making legislation which would abolish them. Miranda v. Arizona, 384 U.S. 436. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protections. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Norton v. Shelby County, 118 U.S. 425. The general rule is that an unconstitutional statute, though having the form and name of law in reality no law, but is totally void. 16 M. Jerval, 2, Sec. 177, 256. Officers of the court have no immunity from liability when violating constitutional rights. Owen v. City of Independence, 445 U.S. 622, and Maine v. Thibautot, 448 U.S. 123. No state shall convert secured liberties into privileges and issue a license and a fee for it. Murdoch v. Pennsylvania, 319 U.S. 105. If the state does convert your liberty into a privilege, you can engage in that right with impunity. Shuttlesworth v. City of Birmingham, 373 U.S. 262. The court is to protect against any encroachment of constitutionally securities. Boyd v. United States, 116 U.S. 616. Constitutional rights must be interpreted in favor of the citizen. Briars v. United States, 273 U.S. 28. We have covered all of these cases thoroughly so that you can see clearly. In the Citizen's Rulebook, the jury has the right to judge both the laws as well as the facts. John J., First Chief Justice of the Supreme Court. The jury has the right to determine both the law and the facts. Samuel Chase, Supreme Court Justice. The jury has the power to bring in a verdict in the teeth of both law and fact. Oliver Wendell Holmes, U.S. Supreme Court. The law itself is on trial quite as much as the cause which is to be decided. Harlan F. Stone, Chief Justice, Supreme Court. The pages of history shine on instances of the jury's exercise of its prerogative to disregard the instructions of the judge. United States v. Dougherty, 473 Fed 2nd, 113.